We've been collecting your questions as they've come into us this afternoon, so we're going to try and address a few of these now. Remember, if you have a question, there's still time to send it in to us before this final session at about 10 to 4. So let's make a start. The first question, we have a tutor who works for us on a part-time and temporary basis. Will we own copyright in the work he produces in the course of that contract?
Okay, well, assuming that the person is actually an employee of the institution, it doesn't matter whether they are part-time or temporary. The sole question is if they are an employee and are they carrying out the work in the course of their employment. If they are doing so, then the material will belong to the institution as long as there's not an agreement to the contrary. It could be that some temporary tutors insist on an agreement whereby they retain copyright in the materials. That might be important if they're teaching at different institutions and doing a tour of the country and delivering a lecture, for example. However, in the absence of such, then if it's within the course of employment, then it will belong to the institution. There is one further complication, and that is if the tutor has written the materials before arriving at that particular post, then it can't belong to the institution. It's at the point of creation this works. So one would have to go back to when the materials are created and look at who became the owner at that point.
Thanks for that. Would a single image, picture or diagram taken from a book constitute a substantial part of it?
Almost certainly. That's substantial has been held to include 11 words in a recent European Court of Justice judgment. Substantial goes to the quality of the material as well as the quantity. So a small and relatively simple diagram could even still be substantial for the purposes of infringement of copyright. It would be a fairly risky decision to take to include a diagram as is from a book into an open educational resource without seeking permission. There may be ways in which the information contained in the diagram or graph, if it's a diagram or graph, could be presented in a different format because copyright only protects the expression of information, not the information itself. Of course, that's not appropriate to an image. Where it's an image, then it's very much likely to be substantial.
Okay, thank you. Do we need a copyright register in the UK? How do I know that someone truly owns the material they claim belongs to them?
That's a very good question. I think I'm not going to go into the policy behind whether a copyright register is a good thing or not. It's not going to happen in the near future in the UK, so I think on a practical basis we can rule that out. With regards to knowing who has the right to grant permissions, I'm afraid then that's a matter of judgment that has to be made in each instance. You want to go in with a healthy scepticism and some sense that, for example, if you're asking an academic about a research paper that you know has been published in a journal, then you want to ask them the question, there's no possibility that you have actually assigned the copyright in this to the publisher. Is that the case? So there's some sort of scepticism, but you have to draw a line somewhere, make judgments as to this. The world continues, that's out there, up and down the UK, people make judgments on this basis. To be absolutely certain that the person owns copyright is actually pretty much impossible because 5 minutes before their communication to you or their meeting with you, they could have actually secretly have assigned it to someone else. And there's nothing you can do that will solve that situation. It's pretty unlikely, though. I think you get people on board. You ask some investigative questions to make sure that you don't have any doubts, and you go forward in this. And it will be taken into account as a factor. If it ever came round to a court case in the worst instance, then it would be taken into account that you had sought permissions from someone ostensibly the copyright owner, though it transpired they weren't.
Okay, it's quite a tricky one. To what extent does informed consent allow for repurposing and creating derivative works?
Okay, that could be addressed in two different ways. First of all, informed consent could relate to data protection. And so say you've got an interview with a person as a video and they're detailing something about their biography, then informed consent will be a consent that allows that to be copied and released, as long as at the time of the interview there were sufficient circumstances to show that was a use of the personal data that was going to be made. A different approach would be somehow changing the format, the omission of names or identifying details by editing of the video so that it wasn't so readily connected with an identifiable individual. Informed consent here could also mean permission with regards to copyright. And again, as long as a person gives informed permission as to the reuse of their materials, that's fine. And again, I think the point I was making beforehand was that it must be very clear that the reuse is as a Creative Commons licensed material open to the whole world. Because if you just ask someone, could I have permission to use it, then that could look like just photocopying it for a class, photocopying it for yourself. It doesn't bring home the fact that it's going to be open to the world.
Okay. Thank you for your questions, and thanks to Jason for clearing up some of the legal issues that our audience are currently having to think about. In summary then, where works are created by employees in the course of their employment and there's no contract that says otherwise, the employer or the institution will own the copyright and the materials can be included in the OER without restriction. Where a licence or permission has been granted by the copyright owner, then the materials can be used within the terms of that licence, so make sure you're clear on what the licence does in fact permit you to do. Where third-party materials are being included without permission, unless you can rely on a statutory exception, as we've heard from Jason, in limited circumstances, then you need permission from the rights holder, and we've heard some practical steps about how you can do that.